Is it a good idea to purchase a home with your partner when you're not married? That's the topic of this video. Hello again, everyone. I'm attorney Robert Flessas. Many people anticipating marriage buy a home with their partner. In most cases, that arrangement works out. But in many cases, it doesn't. The relationship deteriorates and the couple breaks up. It usually follows that one party occupies the home and the other leaves. That obviously creates a legal problem if the parties can't come to a resolution. Before I begin, keep in mind that my videos are not intended to be legal advice. They're to educate my viewers. Always look at the applicable law in your state or consult with an attorney that practices in your state for advice. If you like my videos, please consider subscribing to my channel. I'm building an archive of valuable legal videos on my channel. With your comments, my answers, and these videos, we're building a community educational forum for everyone. Getting back to the issue in this video, let's look at this from a legal standpoint. If you're going to buy a home together, you should think about what could happen in the future. It's only prudent. Not only can the couple break up, but what if one of the partners dies? Who gets the house? Well, let's look at that. First, how are you buying the home? Are you buying it as tenants in common or as joint tenants? That makes a big difference that determines each party's legal rights to the home. What do these legal terms mean? If you purchase the home as tenants in common, then each party has an individual right as a one-half owner of the property. Well, let's say you break up. If the parties can't come to a resolution, the tenant in common can transfer their share of the property to anyone they choose. The remaining owner has no say in the transfer. In the event of a death of one of the owners, then the deceased party's interest can go to their family. If the deceased person has a will, then their share will go according to the property disposition outlined in their will. If not, then the property will be transferred by what's called intestate succession. Intestate succession is usually defined in the applicable statutes in your particular state. If the property is purchased as joint tenants, then the share owned by the party who moved out or dies can't be transferred to another party without the consent of the other. If the party that moved out dies, then the deceased party's interest will transfer to the other owner. So what's all of this telling you? Before you buy the property, you need to consider issues without ignoring the fact that there could be a breakup or a death. What if one of the parties becomes incapacitated? They legally can't make financial decisions any longer due to a health issue. Who's going to make the decision for them if they're tenants in common? The parents who can't stand you? The siblings that hate you? So you need to set up the deed to reflect if you're going to take title together as tenants in common or joint tenants. Sometimes state statutes spell out the presumption, but you need to check your statutes. The solution to a death issue can be resolved by both parties executing a will that sets forth what happens in the event of one of the parties' death. Another solution could be a written agreement setting forth how the property will be dealt with in the event of a breakup or incapacity or death. If there's a breakup, then a written agreement can dictate if the property be sold and the net proceeds are evenly divided to the parties. Or you can allow the other party to purchase the home, buying out the other party's share. But there must be time limits on that arrangement. In the event of incapacity, both parties should have a power of attorney for finances that spells out who's going to control the finance decisions. Here's another big problem. Did you finance the purchase together? Both of your names are not only on the deed, but on the mortgage. In the event of a breakup, what if the party that leaves stops paying their share of the mortgage? Assuming that the parties were contemplating sharing the mortgage payments, now the party that's left is taking a big chance by no longer contributing. The occupying party is stuck with making the entire mortgage payment each month. So what if the party that remains in the house can't pay the mortgage? You all know what's going to happen. When the occupying party gets behind a few months on the mortgage payment, then the bank is going to start a foreclosure action. Since both of you are on the mortgage, you're both going to be named in the foreclosure action. That's going to damage the creditworthiness of both parties. The message here is that all of these scenarios need to be contemplated and dealt with before purchasing a home. By pre-planning, you avoid legal issues in the future. It has nothing to do with love. It has everything to do with dealing with an asset if problems should develop. Well, I hope this video opened your eyes. I'm attorney Robert Flessas. Thanks for watching, and I'll see you in the next video.